Good afternoon, everybody. It's 2 p.m. Tuesday. Question time with Dill, the party wall guy. That's me, by the way. So once again, thank you for coming. This week's show, we're going to go through questions that have come from the previous seminars and shows, and we're also going to look at a couple of new ones. So once again, thank you for your time. I think we're live on one of the Facebook groups as well. So let's make a start. First of all, quick run through housekeeping. This is a Zoom webinar, not a call. So the slight difference is in that none of the participants are viewable, but I'll try and bring you on when you've got questions. No fire alarm, but if there's a fire alarm, it's a real thing. My exit's over here. I'm not sure where your exit is, so make sure you know where your exit is. On your phone, you've got various options for webinars. So this is one of the screens you'll see at the bottom. There's a mic when you come to speak, so unmute that. If you've got any questions, raise your hands, or alternatively here, you can just send in your questions on the chat. Should you get an incoming call, your volume will cut out. You may have to exit and rejoin just to get the volume back. So just to make sure you're aware of that. Please keep it muted until it's your turn to speak. If we lose internet connection, I have got a backup connection. So it'll take a minute or two for us to boot up, so please wait there. And if you get disconnected because you lose Wi-Fi, that'll come back on automatically, so just give it a second. Yeah, there will be recordings available. I've just been a little bit busy. They'll end up on our YouTube channel, which is 1996 Party Wall. And there's I talk about a little gift, which is a PDF on how to do notices. I will be posting those within the description of each of the videos that I post out. So hopefully you can pick them there. And currently updating my book. So if you come across it on Amazon, don't buy it yet. Just by the way, hold on to your money. Question and answers, again. So if you think of questions as you're going along, type them in into the question box and raise your hand. So when I come to ask questions, then it'll be nice to get people on live to ask their questions. We're gonna try that today. So the Party Wall Act, basic. I'm gonna run through a quick basic outline. Why take the process? The schedule of condition protects the building owners from malicious claims. The reason I'm reiterating this, it's common questions that I keep getting asked time and time again. So your project may end up being stopped in midstream. So imagine if you've got the roof off, you're doing a loft conversion or the trenches that have just been about to be dug. The builders are ready, they've completely destroyed the innards of your house, and it stops at that point until you sort the party wall issues out. The Party Wall Act is completely the building owner's responsibility. It's a strict law, so it's not up to the architect, it's not up to building control, or it's not up to your project manager. You're in charge of it. If you don't undertake the Party Wall process, the other thing that can happen possibly is you can get legal action taken against you, which might cause extra costs and again delays. And most importantly of all, it's the law. So the people who should be interested in us are people who own the buildings, building owners. If you're a developer and you do it at a profit, even more of interest. If you're a finance company, a broker, and so on, you need to be aware of this. If you're a property manager, an investor, or an estate agent, you need to make sure you understand how the Party Wall Act works and how it can affect you as an adjoining owner on the other side. And architects, the reason I keep talking about architects is these are the guys that initially introduce people into the Party Wall Act, although it's not their job, but it becomes a part of their role just on the side because most people are new to building works. So basic terms, you have the building owner now. This is the owner of the property. Excuse me, it could be a legal owner, it could be a company entity, it could be two people. So it could be a sole owner or a limited company, but they're responsible, or a corporate body. They're responsible for making sure party wall issues are complied with and notices issued. And on the other side, you have adjoining owners. Now, there's 4 classes of adjoining owners, and within the class, you can have multiple owners. So you have the freeholders, quite self-explanatory. Leaseholders of more than 1 year. So remember, we can get leaseholders of less than 7 years that aren't registered, and leaseholders of 99 years are usually registered on land registry. So leaseholders of more than 1 year. So there's a little blind spot between 1 year and 7 years. Make sure those we need to account for those people as well, where possible, that group of adjoining owners. You also have people who have rights to receive profits. So this could be a lease purchase option or a rent-to-rent agreement. These guys have, again, rights to receive profits from the land, and it also involves trusts on a number of occasions. If you're contracted to buy land, so if you've just exchanged on a house and you're going to buy it, you become a notifiable owner legally. If you're in negotiations and you've made an offer, it's been accepted, that point isn't quite reached yet until you become under contract to buy land. But you as a building owner, if your neighbors are selling their house, you just try and start engaging with the new owners. People who aren't affected are short-hold tenants, council tenants, and mortgage companies, so they're not notifiable owners. Quick run through the basics of party wall process. It started at stage 1 by the building owners. This is not a party wall agreement, so day in, day out, we get calls. We've sent a party wall agreement, they haven't signed it. It's simply a notice. So the building owner starts the process by sending a notice across, serving a notice, and it's the adjoining owner that decides what happened in the next stage. So the adjoining owner can decide for a schedule of condition, and a schedule of condition actually protects the adjoining owner. So it's there to protects the building owner as well as the adjoining owner. So there's no argument. So whether the damage was there before or if it's new, and a number of occasions we've gone into properties where we've seen damage, we've logged it, photographed it, and the building owner, the adjoining owners have said, well, it's not there, I didn't see it. So it's just because they become familiar with their circumstances in their house. And, we all delete things mentally. So we're deleting them while we're passing them every day. We just become familiar with them. And that, as I said, is there primarily to protect the building owner from claims by accident, false claims, and sometimes even malicious claims. Now, a ward is what can be, is the legal document which can be termed as a party wall agreement. It sets out the rights and responsibilities of each of the parties concerned, and it also contains procedures if there's damage and how to deal with it without going to court. Quick run through again on building owners' perspective. The Act is written in section numbers. It does talk about walls and foundations, but it doesn't talk about actual works in terms of how we're familiar with it. So, we think about rear extensions and lofts, or removing chimneys or basements and sometimes porches. So these are the top 5 projects that we see in a residential setting. So all I'm trying to do is map on section numbers as a way of explaining how the Act works. I have a feeling I might end up adding outhouses to this little slide as well. So we have a question that's really left over from last week's question where we went through outhouses. Just in case you missed it, that will end up on YouTube, I think, another week or so. So that little last week's question time will end up on YouTube. You can watch it on there. So the follow-on question from the outhouses we've had from one of our viewers. What if my neighbor has built on my land? So, and this comes under trespass. So if we imagine this is a building, that's the neighbor's building. They built an outhouse. This is where roughly, so all the gardens intersect, and they've crossed the line in terms of building their outhouse across and building onto your land. So if this is your house, if this has been done, this is not covered under the Party Wall Act because it's already been done. This comes under the law of trespass. So what they're doing is actually trespassing. It is a boundary dispute. Now, and same can be done whereby they build an extension and they come onto your boundary. Now, there's a couple of things you need to be aware of on this scenario. Yes, people trespassing on, neighbors trespassing on neighbors' land is very, very emotional, and people get very upset about it. I was actually on a seminar last week about boundary disputes. So this is a completely separate area of law. It's got nothing to do with the Party Wall Act. It all depends on how much they're trespassing, the degree of trespass, and whether that affects, say, your access or if it has strategic value. So where we've got 50 mil or 100 mil, there's no strategic value. Again, rear extensions. It's not very nice, but it'll probably cost you a fortune to do it, and you can get into an argument and dispute for no reasons. Now, where they've trespassed even further, you may have to think about taking it to action, but usually judges don't usually make people knock down their buildings. It's very rare. It might be financial compensation, and on an average house in the outer suburbs of London, we're looking at sort of £500 per square meter, and court costs can run into not just thousands and tens of thousands, but multiple of tens of thousands. So just be aware, just once more to close it off, it doesn't come under the Party Wall Act. It's a case of trespass. And if you're going to go and see lawyers, you need to be careful and be aware of the court costs that may be involved. So that's just a follow-on question from last week's question about outhouses. So we've had another question in from one of our viewers. I think they might be on the line. If you'd like to ask this yourself, please put your hand up. If not, don't worry. If you're not brave enough, don't worry. I'll go through it anyway. So just want to make sure my mic's on. Yep, the mic is on. The question extract is, sorry, I haven't completed a section yet. I'll go through what they mean by a section. It's different to a section number. Building owner foundations are approximately 1,500 to top of the foundation with as a shared sewer, and runs across an extension with an invert at 1,250. So I think what they're saying is they're 1,500 in terms of the depth they're going to, and there's an invert which is a piece of the sewer that you get. So it's originally for access and so on. So it's going to a depth of 1,500, and I think what this person's trying to ask is, what section do I need to serve? So just before I go into that, there's a question, there's an element of the question I'd like to deal with here, which is a section. So section 6 requirements. So section 6 notices require that you issue and this is the only notice that requires drawings and plans and sections, that you issue that it's accompanied by plans and section showing the site and depth of any excavation, and the building or structure and its site. Now, these two elements, the building and its site, are normally done when people draw up plans. So when they draw up a rough plan, very basic plans, they'll have some sort of building, they'll have some sort of elevations. They'll also have a site plan, which is on the land registry. Most drawings have them, but the architects don't always attach them. So the bit they always miss out is this bit on sections. And I've got an example here. This is roughly a section 6 section, if you like. Now this relates to excavation foundations on eccentric foundation. Eccentric foundation section. It's an example. So take a note of this, and you could use similar ideas. So the reason it's an eccentric foundation is we're building on the line of junction, which is here. So there's no foundation crossing this bit. Now, if your boundary stroke line of junction is not to the edge and it's here, so you'll obviously have to draw this slightly differently. But the important part is to show the depth. Now, this depth is, you may not have done your building control regulations just yet, but it's important to have a section. So you can have an approximate idea of what they're going to be. It's usually between 1,000 to 1,200. So somewhere along there. And then later on, it's possible to revise that if it needs to. But just a quick call to your building control guy, building X, Y, and Z. So we're building a single story extension. What's going to be the depth? And most people know this because they do this day in, day out. Or we're building a double story extension. What do you think the depth is going to be? And therefore you could draw a section from it. Now, obviously where you've got a commercial project, you might entail piles and so forth. So that's the question to ask right at the beginning. Say, we're doing this, what's the loading? Give us a section. You can finish off all the other building control stuff afterwards. This is important for excavation purposes. And probably next week I'll try and bring in the other sections that might be needed. So you might have a section where, sorry, a section for section 6 where you're not doing eccentric foundations, or where you're doing piles and so forth. So I'll try and bring those in next week. But that's roughly all it's doing is showing how deep it's going. And I had a question from one of the adjoining owners. They said, look, guys next door have served me a notice. They haven't said how deep they're going. You know, for all I know, they could be digging an oil well next door, and it's going to affect my property. So it's always a good idea to do this anyway, and it's just to make architects aware that they do need to add this in. Okay, so one of the other questions I've had, and which is really interesting, which notice do I serve, section 6.1 or section 6.2? So just to recap on section 6.1. Now this section applies where a building owner proposes to excavate where any part of the building or its structure is within 3 meters of the adjoining owner's building, or where the excavation is within 3 meters. And don't forget the and, because that's quite important. It's a dual purpose test, not just one. It's also being excavated to a lower horizontal level. So don't forget, it's any part of the adjoining owner's building, not just all the building, any part of it. So usually this is where you get existing houses, and if the corner is within 3 meters, they are notifiable. So again, that's the law rules. Just don't forget the and bit, within 3 meters, lower level. So let's have a little mock up here. Is a scenario. We've got 2 houses, and here we're showing projecting foundations of the old existing house. So that's the adjoining owner. This is where we're going to count the distance from, allow a little bit for their projection. And usually what happens is if you're measuring to the wall and it's close to 3 meters, you could say there's going to be a bit of projection foundation, so you can add that on. So if that's 3 meters, so that's rule 1, test 1. And if it's to a horizontal lower level, it ticks off both of these tests, so it's notifiable under section 6. Now, the section 6.2, sorry, going back, that's notifiable under section 6.1. Now, section 6.2 is slightly different test. It also applies where the distance. Now here you're looking at within a 6 meter distance, and I'm not going to read all of this bit out. It's a 45-degree angle. This actually is quite a complex test, but the way to remember this bit is if you're going to a depth of 6 meters, you need to look at buildings within 6 meters. Now, the way I'm going to talk about this here, it's an incorrect way of thinking about it, but it's a shortcut way of thinking about it. So, and be careful on this. It's just a way to think about it to work out which section you want to go into. So if this excavation here is 3 meters or less, section 6.2 is not going to apply, because we only need to think about within 3 meters of it. So if you're excavating within up to 3 meters or below, now, not the right way to think about it. No, this isn't how Section 6.1 works, but it's just a way of addressing what you're doing. So if you're excavating up to 3 meters from this point to downwards, you're looking into Section 6.1. Now, I had a call from a builder, from a developer stroke builder. They're looking at doing modular schemes where they just crane off an outbuilding and so on. And they were using piles. So for piles or for excavations of more than 3 meters, you need to look at Section 6.2. Now, if you're going to 6 meters or below, then the 6.2 gets quite simple. You look at any buildings within 6 meter, they're probably going to have a foundation and assess whether they're within 6 meters. So where you're going more than 6 meters, that's fine. Now you do get a gray area where you're between 3 meters and not quite 6 meters. So the way to think about that is you work out the depth of your foundation and you measure across and you see if there's any similar buildings to that depth. Now, I'm going to see if I can get this whiteboard technology on to try and explain it. No, not going to try that one. So forgive me, forget the whiteboard idea. I'll have to try and do it a different way. Okay, so if we're going pretend, let's assume it's 4 meters. This depth is 4 meters. So to form this 45-degree angle, this is basic primary school mathematics, geometry, if you like, but at least we found a use for it, Pythagoras theorem. If this is 4 meters, it's not quite Pythagoras theorem, it's trigonometry. This is 4 meters depth, then we only need to look at buildings within 4 meters to form this 45 degrees angle. If this was 5 meters, then we'd look at 5 meters. And if it's 5.5, you just need to do 5.5, although you're getting quite close. And again, if it's 6 meters and over, so where you've got piles of going down to say 7.2 and so on, it's just up to 6 meters. You don't need to go to 7.2. So hopefully that explains that little question we've had. Again, just reiterating onto the first bit about trespass, boundary versus a line of junction. And again, this fits into eccentric foundations. The boundary is all the way to the sky, to the bottom of the earth. You can get aeroplanes flying over, that's a different law, so we're not going to go into that one. Line of junction is where the two lands meet and there's no building on it. Might have to do an interesting section on where you've got a garage and you want to do a double-story line of junction not applying. So we'll look at that in a future program. So there's your line of junction. So if you're building on the line of junction, again, section 1. So those are the old outstanding questions. I'm going to go through a quick run of how architects can help to improve the process. This is just what I'm saying is how we can help architects to help their clients and try and get a better result in terms of either an agreed surveyor or a schedule of condition. So just to reiterate, we get 3 types of architects, and these are the guys who will completely ignore it. Just put it in the notes and say, it's your problem, I'm not going to deal with it. Then you get the guy, and I'm guessing that, so the guys who completely ignore it, they're sort of doing the right thing, but it would be helpful if they can just send their clients an email saying, you need to look at this, and we don't deal with it. So that's a good way of dealing with it. The next group we get are the guys who will try and be a little bit helpful, but by being slightly helpful, they're in fact causing the clients difficulties, whereby they'll draft a notice and they'll give it to their client, say, you need to serve these. But a lot of our work involves explaining the process, going through all the possibilities and so on. And it's A, it's time consuming, B, there's lots of different iterations. So, and be fair to these guys, it's not their job, but they'll hand the notices to their client and say, you deal with it. So the notices, and the clients don't know what to do with them afterwards. And it's almost like you're going to an X throwing course whereby you're trying to throw an X without hitting your partner. So that's also a difficult way of dealing with it. Now, on the third side, you have some architects who do it, and I do get calls from architects who do undertake the party wall process. And because they don't do it full time, they do have problems in how they deal with them. So if you're one of these guys, give me a call. Happy to help you out. Let's see if I can help you out of a situation you're into. So what improvements can architects make to help their clients? They might not like it, but you need to tell them about the party wall process as soon as possible. And if you need to explain it and you don't have the time capacity, redirect them to our YouTube channel. In a couple of weeks, we'll have loads of resources on there, so they can just sit there watching it. It'll be time efficient for you as well. A lot of the times they'll serve notices to adjoining owners without having their details. So you need to get the details from land registry, and that's the only addresses you need to serve to. It is helpful to hand them to them or put it through their letterbox if you want, but it's the address on the land registry that must be served to. So as I mentioned before, drafting notices and giving it to clients is actually not helpful, and it's taking up your time. So either you do the whole process or do nothing at all. So in that sort of scenario, you might be better off just saying you need to deal with it and fit it into this first element. Now, a lot of people, and it's just not architects. I've had lawyers, I've had property developers. I've really had people that I think should know better, and they don't know about the 10-4 process. So, and that's one of the issues that gets missed out. And because they don't understand it, they don't do the service of notices properly to plan for the 10-4 section. So that's one of the things they need to be aware of. And again, they don't complete the process. So it's a case of, and sometimes you get difficult questions from neighboring surveyors, joining owner surveyors, and you have to deal with them, and they haven't dealt with the process in the right way. So they failed to set up a third surveyor or selected a third surveyor, or answering their questions in what they want. A number of times we've come across problems with the process, and it can get very difficult. So the other mistake, and it's not just architects, everybody makes, is you go to the post office and you'll say, can you please give me a certificate of posting for these letters? And they'll try and be helpful and say, would you like a recorded delivery? Sounds like an important document. That's why you're asking for a schedule of condition. And you have to be quite firm on this and say, no, thank you. Just certificate of posting, please. And you need to keep that proof on your file. So you can either scan it in or keep the physical little tab. And next point, obtaining and keeping that certificate of posting as proof. Now, once you get a certificate of posting, it's deemed as proof. So, whether it gets to the neighbor or not, they can't argue with that. That's the Service Act, deemed Service Act. So the more helpful tips, usually everybody thinks, oh, well, let's get the planning and then we'll deal with the party wall process. So that's understandable where your planning is risky and you're not sure you're going to get it. So for projects under PD, now this is where you got residential stuff. You know it's going to happen. You know you're going to get the planning. It's just a case of getting the certificate. And that's where your application is in for. So as soon as your first idea is ready, roughly you know where the extension is going to be. You haven't finished planning out the kitchen, where the lights are going and the building control and all the rest of it. As soon as your first draft is ready in terms of the outline of the building, so that we can work out where you're going to be excavating, and we're not worried about what color you're painting everything, where your kitchen's going, or if you're putting loft windows. That doesn't affect us, or how you're moving the windows. All we need is roughly an outline of where your building's going. So at that point, when you've got first draft of your drawings, you should serve the notice to your neighbours. The reason being, and then complete your drawings, and then follow the planning process, and then you're ready for build at this stage. Put the build arrow in as well. So we can finish the party wall process by the time planning's confirmed. Not only can we finish the party wall process by the time you get your planning, and a lot of good loft design build companies that we work with undertake the process in this way. They actually allow 3 months, and that's a good time scale. We'd like as much time as possible. So look, we could complete it and so you're ready to build when the planning is confirmed. Remember, we're talking about PD here. So now the most significant reason for doing it this way around is as soon as you put the planning in, so if we went to the previous slide where you put the planning in, within a week of you putting the planning in, the adjoining owners are going to start receiving letters from other party wall surveyors marketing their services as adjoining owner surveyors. Now, it can create bad feeling, i.e. these guys are doing something and they haven't told me, or they're trying to hide something, or they're not going to do the party wall process. Doesn't matter how familiar you are, how happy you are with them, how much of a great relationship you have with them. That creates that feeling. So sometimes they end up filling these letters in and signing them anyway. And we've had conversation with building owners where they say, it's all right, my neighbour's great. He'll consent to a schedule of condition or go with an agreed surveyor. He's not going to create problems for me. And we've talked to the neighbour, and he's talked to the neighbour, we've talked to the neighbour, and they've appointed someone just because they didn't realise what they were doing, or they thought their neighbour was hiding something. And in normal circumstances, they would have gone with agreed surveyor, which would have meant lower fees or a low or a schedule of condition. So that's something to bear in mind. Here's a gift I talk about. So this is completely free. This is a new updated version of the government booklet. It's a very good booklet. There are some errors, and it was written in 2002, I believe, although it's not on this bit. I'm a member of the Faculty of Party Wall Surveyors, which is the organisation that they list here. These guys are great. You can get advice from these guys as well. And when we looked through this, and we were getting loads of questions on the 10-4 process and various other things, and the notices can be quite confusing. We put together this little booklet, which is free for you. You can connect with me on my LinkedIn and download it. I'm going to attach it to this video. You can download it from there. And it just runs through the series of steps to take. So your notices are served properly, and you can actually keep a record printed out, keep a record, tick it off, and do this scenario. So hang on. So basically that's the end of the question time for this session. Thank you for coming. And thank you to our sponsors. Couldn't be here today, so sponsored by Property Investor News. Great magazine. In fact, I've got it here. So if you're involved in the property business, this is quite a good magazine. This one's really great. This one here. Just for subscribing, they'll send you last 3 months issue, so you'll still get the COVID special edition. And you'll also get this book. The book's really good as well. I know the author. So if you're in the property business involved, go and talk to these guys. They're our sponsors, and we're grateful that they're sponsoring this and gives us a chance to talk about party walls every week. The other sponsors are Rent Kitchens. These guys couldn't be here either, but you know, if you're looking for a kitchen, and if you're an architect, send these guys your drawings, get them to draw the kitchen out, look up. Just means you're giving your customers extra service without actually having to put any more work in. So let them do the work for you. And where you're doing a rear extension in your kitchen, they can create some really nice designs, really great guys. That's the details. If you speak to Sanj there, that's his numbers. So that's great. Please keep your questions coming in every Tuesday, party wall question time. I think I'm on time. I might have spilled over a little bit. So I've spilled over slightly. So But always great to get questions coming in, and I'll see you next Tuesday. Thank you for your time.